Hi, welcome back. I'm Jessica Eves Matthews, and this is Trademark Examples from the Trenches, David versus Goliath. Today's episode is going to be a little different. We are diving into some real world trademark battles, some famous, some you probably never heard of, that are going to show you what happens when brands collide. And crucially, we're looking at this from the perspective of startups and small businesses. Sometimes big companies steal from small ones. And sometimes big companies will bully small companies over marks that the small ones have every right to use. Understanding some stories in sort of a real world context will help you know when to fight, when to fold, and how to protect yourself if you find yourself in this situation. I'm going to share 3 categories of trademark battles and lessons that they teach. First, when the big guy steals your name and how companies won. Second, we're going to talk about when big companies bully and how to fight back. And third, we're going to talk about some famous disputes and the strategic takeaways for your business. Let's get into these war stories. Number 1, when a big guy steals your name. Let's start with a David wins story. Back in 2013, a company called Fleetmatic, all one word, was providing GPS fleet tracking. And it was software that they were selling to small businesses. And they had been operating for years. And then tech giant Verizon launched a competing product and they called it Fleetmatics. Notice the S at the end, that's the only differentiation. The small business Fleetmatic did not back down. They documented their prior use. They showed clear customer confusion between the two brands, and they actually fought back really hard. The lesson in this was that prior use matters. So when I say prior use, I'm talking about who was using the mark first in commerce, who was making sales of goods or services in commerce, meaning around the US first. And if you do that, you have the rights in the name, even against a giant company. Verizon eventually acquired the infringing company and rebranded, but only after Fleetmatic stood their ground. So that's a great lesson, right? Because you should hold your ground if you have prior rights, and the outcome could be very beneficial, whether you get paid a settlement amount, whether they acquire the mark from you, whether you actually force them to cease and desist, or maybe you'll actually win a judgment at trial. It's worth it to hold your ground if you have prior rights. Here's another example. A small chocolate company named Choco Love had been making premium chocolate bars for years when a much larger competitor launched a suspiciously similar product line with nearly identical packaging. Same color scheme, similar typography, similar wrapper design. And Choco Love smartly documented everything. The way you do that these days is you're going to screenshot. That's usually the way you're going to be able to preserve this. Make sure you have dated screenshots that show the URL where you found that proof of their infringing use. And because they did this, they filed a lawsuit and they won. And the competitor had to pull their entire product line. As I mentioned a second ago, that is one of the potential outcomes for holding your ground. What's the pattern here? Documentation and timing. These small companies were able to prove that they were first, they were using the mark first, and that the bigger company copied them. Potentially consider reverse confusion, by the way, if you're interested in what that means. It's where a big company, which is actually the junior user, comes in and starts using a mark that belongs to the senior user, meaning the first user, which is a small business. That's David. The big company's Goliath. And because the big company has vastly greater resources, they're able to basically crush the smaller business and sometimes close to out of existence. And that is called reverse confusion. And that is one of the grounds on which you would use to go after a big company for this type of thing. Okay, let's talk about the next section that I mentioned, when big companies bully and when you can win. Sometimes this is called trademark bullying. And this is when a large company sends an aggressive cease and desist letter to a small business, and that small business is actually not infringing. But the big company is hoping they'll be too scared or too poor to fight back. Even though the big business does not have prior rights or senior rights, it sends this letter hoping that it will bully the small business into capitulating and giving up the mark. One of my favorite examples from 2017 is a small craft beer company in Vermont called The Shed, which received a cease and desist from Facebook. Why? Their beer was called The Shed. Facebook claimed that it was too similar to their Meta branding. What? The Shed, Meta? How are those even close? They're not. And the Shed fought back and publicly called out the absurdity, and Facebook backed down. So here's another one. A small restaurant called Exit 6 Pub and Brewery got a threatening letter from Starbucks because one of their beers poked fun at Starbucks in a parody way. And the owner wrote back a hilariously sarcastic letter and sent Starbucks a check for $6 representing their alleged lost profits. And the reason for that, which is really hilarious, and the story went viral, Starbucks dropped the case. But the reason it was only $6 and the reason profits are relevant is because if you are found to have been infringing on a mark, the remedy that a court will normally order is what's called disgorgement of profits. The infringing party, whatever profits they made off of that mark, they have to hand over to the rightful owner of the mark. Well, in this case, they obviously only made $6. That is a very clever way to push back on a big company's attempt to bully. And we can't forget the case of a small brewery in Oregon, I seem to have a theme here, that received a cease and desist from Monster Energy over their beer called Vermonster, cute name. Monster eventually lost because the marks weren't actually confusing and the beer wasn't competing with energy drinks. There are two different classes of goods, different products, different markets. The lesson, Goliath doesn't always win. And in fact, I would venture to guess Goliath doesn't typically win. There's no actual likelihood of confusion in those cases. And when that's the case, that there's no actual likelihood of confusion, like if you're in a completely different market, or if the claim is absurd on its face, or if you actually have the senior rights in the name, you can and should fight back if you're able. This is something I do for my clients. One of my favorite things to do in my practice is represent small businesses who are being bullied by big companies or who are fighting big companies for infringement of their small business's mark. Let's talk about this third section in this video about famous marks and hard lessons. This is a fun one. These are famous disputes and what they can teach us about trademarks and how to protect ours. Let's look at some of these famous cases. First, Apple versus Apple. Apple Corps, the Beatles record label, and Apple Computer actually fought it out for decades over the Apple name and logo. The original agreement said that Apple Computer could use the name as long as they stayed out of the music business. They had what's considered a coexistence agreement with Apple Corps, which was the original Apple brand, envisioned being in the music business at that time. And so they agreed to not expand into that space. Well, then iTunes happened. And we know what happened from there, right? This case eventually settled for a reported $500 million when Apple Inc. had to come to the table, but they ultimately ended up getting all the trademark rights and licensing back to Apple Corps. And so the lesson is be very careful about coexistence agreements. And I've done another video on this. I've actually done a couple, I think, on what they are and what the risks are with those. So you always have to think when you're agreeing to coexist with another mark owner for a very similar mark, you really have to think long-term for your business. Am I going to potentially want to expand into the space that they're in? And if so, you don't necessarily want a coexistence agreement because it can really come back to bite you because markets change. And that happens, pretty frequently. Here's another example. This is a Budweiser dispute. Two companies, American Budweiser and Czech Budweiser Budvar, had been fighting over the Budweiser name for over a century. And in different countries, different companies own the name because each country has its own trademark agency and registration process. If you have a trademark in the US, it doesn't give you any protection in, say, the Czech Republic. They were fighting over these marks, and neither one has ever fully won this debate or this fight. The lesson here is that trademark rights really are territorial. So being first in one country does not give you rights everywhere. And in some countries, you get priority rights not based on you using it first, but on filing for registration first. This is where having a good trademark lawyer on your team is really useful if you think you're going to be expanding into other countries. And by the way, we are in an increasingly global world. If you have a website, you're already operating in other countries, whether you realize it or not, if people from other countries can purchase from you. And if you want to protect your name in those countries, you need to have some assistance in doing that so that you want to make sure you're not expanding into another country and actually infringing on an existing mark in that country without realizing it. Those territorial issues are extremely important and not always easy to resolve. Just remember, being first in the US doesn't mean you have automatic rights in other countries and vice versa. Here's a lesson in how strong marks can become too common. Aspirin, escalator, thermos, even heroin. These were all once trademarked brand names that became generic because the companies did not protect them vigorously enough. This is called genericide. It's where the mark becomes generic. Maybe it started out as unique, and then because people began to use it as a descriptor or a noun or a verb instead of a brand name, it ultimately became generic. The lesson in that is that you have to actively enforce your trademark. One is to get registration. The second is that you want to actively enforce your trademark, meaning you must go after infringers and prevent people from using your mark in a way that would render it generic ultimately. And so this is sort of an ongoing thing, and it's sort of one of the downsides of being really successful at something. When you think of like Google, for example, people use that as a verb, and Google works very hard to protect their brand name, but there, I think, is a very strong chance that at some point in the future, the word Google could become genericized as a trademark. Xerox is another one that has fought this. Velcro is another one that has fought this very aggressively because people tend to use those words as descriptors or nouns or verbs. Band-Aid is another one. So those last ones I mentioned, they've all succeeded in keeping their trademarks, but it is an ongoing effort. If you have the good fortune of being wildly successful, you need to make sure that you've got somebody like a good trademark lawyer helping you manage this so you don't risk losing the rights to your name because of how successful you are. So remember, you've got to actively enforce your trademark or you can lose it. Okay, now to the fourth section of what I said we talk about in this video, how to respond when you get the letter. Now, I have done full videos on this before, so I'm not going to get into a ton of detail, but I want to touch on it. What do you do if a bigger company sends you or your small business a cease and desist letter or demand, claiming that you are infringing on their mark? Well, first of all, call a trademark lawyer. I would never recommend handling this by yourself, but here are the 5 questions to ask before you respond. The question you ask first is there actually a likelihood of confusion? Meaning, would consumers be confused between the two marks? Are you in the same industry? That's like the first most important question. Is your mark really that similar? Now, if you got a certain mark and then the big company is using it and just added an S on the end, that's pretty similar. And the similarity can be visual. It can also be phonetic, right? If you say it out loud, it sounds the same, even though it's spelled differently. And then you want to ask, are your customers actually confused between the two brands? Have there been actual instances where your customers have told you that they're confused? If the answer to these questions is no, then you may have a strong defense, even if you aren't the senior user, even if the big company is. But that leads us to question 2. Who was first using the mark? You want to check the timeline. Did you start using your mark before they registered theirs, before they started using theirs? If so, you may have prior use rights. One really good way to figure that out very quickly is to look at social media, because often that is a good way to predict or understand when a brand started using the mark. Go to their very first social media post on Instagram, for example, and often you can find the earliest date they were using that mark. That is a very handy, quick way to sort of get that insight very quickly. But a good trademark lawyer can help, knows exactly how to do this type of research and help you figure this out. Number 3, is the use parody or fair use, right? If your use of the mark is clearly a parody or commentary on that company, for example, that is protected speech. That's not really a trademark issue, but it gives you the ability to use the mark. And there's a really famous case with Jack Daniels that just came out. There was just a ruling on it this, 2 years ago now, because there was a brand that was making dog toys and it used the word Jack Spaniels instead of Jack Daniels. Ultimately, it was found to be infringement, but it's a really interesting issue to see if you can use it for parody purposes and or commentaries, if there's like a social issue involved in it. Number 4, is this a pattern? Look for evidence of trademark bullying. If they're sending letters to everyone, if this is sort of their MO, look for that. If the claim is clearly weak, then that's a pattern that can work against them. And it's something a good trademark lawyer that you hire can use that and turn that on the big company. And question number 5, what's the smart business move for you? Again, you want to talk to a good trademark lawyer about this. And I, along with many other trademark lawyers, offer free consultations, and I can help tell you honestly if you have a case, because fighting back is certainly going to cost money, but so can caving in to an invalid claim and having to rebrand your entire business, rebrand your inventory, re-educate your clients or customers. You've got to weigh the cost of those two things and determine which one is the better course of action for you. And a good trademark lawyer like myself can help you make those decisions. Let's talk about strategic considerations. These are just my few final thoughts. Sometimes the right move is to rebrand. If you're clearly infringing, if you took somebody else's mark and barely buried it, then that's a problem. If your mark is weak, that's an issue as well. Fighting might cost more than starting over with a really strong, unique brand. Again, remember the ladder we talked about as far as strength of brands in a previous video. You want one of the top 3 rungs. You want fanciful, arbitrary, or suggestive marks. You don't want descriptive or generic marks. And so you've got to keep that in mind when it comes to determining the strength of your trademark. But if fighting would actually cost more than starting over, sometimes it's worth it to rebrand. And that is a legitimate choice. I have a client that did that a number of years ago who had a very successful skincare line and spa in New York City, got hit with a cease and desist from a competitor who did not have prior rights. My client did, but ultimately she decided to rebrand, and her brand today is wildly successful. And it was actually the best thing for the company to rebrand because the previous name had actually been more generic, less memorable than the new ones. Don't let ego drive you into an expensive battle or an unwinnable battle. Think about what's in the best interests of your company, but also know your leverage. Big companies do not want bad press, especially if they're bullying a small business. They do not want to look like bullies. Sometimes a well-placed story in the tech press or a viral social media post is more powerful than a legal brief. Sometimes you can start there. Just be careful if you do that, that you're being factual, you're not engaging in defamation of any kind, and make sure that you actually have the right and strongest position. That brewery that sent that sarcastic letter to Starbucks, they probably would not have won in court. Actually, they did not have the stronger position, but they won in the court of public opinion. That can be very effective, but you also have to be careful that you're not doing something that would harm you in litigation. Again, I would encourage talking to a lawyer before you do anything like that. And then consider settlement creatively, because maybe you can coexist in different geographic areas. Maybe you could add a modifier to your name that creates distinction, like your name. And he was not going to get registration in the name. And so I recommended that he add his name, Dr. So-and-so, to the front of the mark, which he did. And we secured registration very quickly. Sometimes you can add something to the front that will create the distinction that you need. It will also prevent you from infringing on another mark. But not every trademark dispute has to end with one side destroyed. So if you're in the middle of a trademark dispute right now, whether you're being accused of infringement or someone copying your mark, don't go it alone. I do not recommend that. Just set up a call with me. We'll work through this together. I'll help you evaluate your position and understand your options and figure out the right strategy for your specific situation. It's really important to have someone in your corner who's seen these battles before. Just use the link to sign up for a free consult with me, and we'll get this moving for you. Let's recap. The 3 categories of trademark battles are: 1, when a big company steals from a small one, you need to document your prior use and document their use. The documentation is your greatest weapon. Number 2, when big companies bully small businesses, sometimes publicity and persistence will win the day. And number 3, famous disputes teach us that markets change, rights are territorial, and you have to enforce your marks or you risk losing them. In a coming video, we're going to get into a scenario that generally terrifies founders. And that's when you received a cease and desist letter, someone claims you're infringing, and they seem serious. I've done a couple of videos about this actually to walk you through what not to do when you're facing this issue, how to respond, and how to protect yourself. Look for that in one of my other videos, and I will see you on the next one.